You're listening to Legal Talk Network.
Hello, and welcome to our podcast live from the ABA section of Antitrust Law Spring Meeting 2018. This is Melissa Whitehead, and I'm the host for today's episode, which is being recorded on location at the ABA section of Antitrust Law Spring Meeting 2018 in Washington, D.C. Joining me today, I have Scott Martin and Bruce Simon. And welcome to the show, guys.
Thanks.
Thank you, Melissa.
We're going to be talking about what it's like on the plaintiff side of the V. Before we get started with my questions, why don't you all tell us a little bit about yourselves, like where you work and what you do?
Sure. Melissa, my name's Scott Martin. Bruce is being his polite West Coast self and letting me start first. So I'm a partner at Hausfeld, which is a claimants or plaintiff side firm in New York. We started the New York office about 3 years ago. I will tell you that my time before that, for over 20 years, was spent principally on the defense side. Bruce has been, we're here at the spring meeting, Bruce has been recruiting plaintiffs' attorneys, I think, to the ABA for longer than I've been a plaintiff's attorney, which has been a successful endeavor. We had a terrific turnout at the plaintiffs' reception last night. Seems to grow every year. But my time was mostly spent for about 20 plus years at Weil, Gotshal & Manges and at Greenberg Traurig, both firms of over 1,000 attorneys. And principally doing defense side work, principally doing antitrust work. That's a switch that I made about 3 years ago. So if you go back and look at some of the comments that I've made over the years at ABA events, they would probably be ones that I might just modify a bit these days.
And how about you, Bruce?
Well, I grew up in San Francisco native. There are not too many of those anymore. Stayed close to home, went to UC Berkeley for undergrad and UC Hastings College of the Law in downtown San Francisco. I've primarily been on the plaintiff side my whole career. I did a little defense work for a couple of years at a firm in San Francisco, and I figured out very quickly that most defense attorneys would rather be plaintiffs' attorneys, and I certainly didn't like that part of it as much as helping people out. So my firm is Pearson, Simon & Warshaw, LLP. We have offices in Los Angeles and San Francisco, and it's been a great 10 years that I've been at that particular firm, and we're in lots of big things, as Scott knows, and really looking forward to the next 10 years.
Thank you. I want to start first with the most obvious question, which is why the plaintiff side? And Scott, why don't we start with you? And I'd like for you to talk a little bit, too, about how you may have found the light, as some people might say, and made the transition over from the defense side to the plaintiff side.
There are many people who say that, or glad you're not on the dark side anymore. All these things. I did not figure it out quite so expeditiously as Bruce did. It took me a number of years. In fact, I'll tell you, I went to college and law school at Stanford in Northern California, and somehow I seem to have made the wrong turn and wound up with New York winners, too. So I should take a little life coach advice from Bruce.
We have a Cal Stanford thing going on here. Yes, that's right. That's a whole different podcast.
I think what attracted me to the plaintiff side, at least intellectually, there are a number of things that occur in large law firms, including dealing with conflicts when you have a lot of corporate clients, and there are some things about the plaintiff side for many of us that we find personally rewarding, wearing the white hat, to use the time-worn expression. But from the perspective of a practicing lawyer, I think what attracted me most was that you start out, and for those who dream of writing the great American novel, but grounded in fact, that's in many ways the exercise that you go through when you're writing a complaint. You tell a story. For those who have been in some way felt pigeonholed or constrained on the defense side to looking at one or two particular defenses or ways to get rid of an action, That's not something you do on the plaintiff side. You start out and throughout the course of the case are constantly thinking about how you would try it, how you would prove the case, how you would establish each of the elements, what's going to be attractive, to a jury, and how you're going to develop the evidence. And from that perspective, it's really an incredibly enjoyable exercise for those of us, who are litigators.
So what was it? Was there any specific point in time where you decided, all right, this is it, I'm making that switch?
There was an epiphany, and it did in fact happen in the most, the most banal sort of way, which was it was one conflict too many. I happened to pick up the phone that day and got a call from an old friend of mine on the plaintiff side, Michael Hausfeld, who I'd known for 15 or so years, and he sensed my anger that particular day. I wasn't angry with him, but just in general, and asked me, what was troubling me, and I told him, and I made a life-changing comment. I said, Michael, some days I just feel like saying to heck with it and going to the other side of the V. And there was silence on the line, and never one to miss an opportunity. Michael said, I'll come up tomorrow. We'll have lunch. It was a 3-hour lunch. It was followed by a 3-hour dinner, and a lot of things just fell into place and made sense in terms of, my perspective.
And how long ago was that?
Well, that was about 4 years ago.
And now, Bruce, you have been on the plaintiff side for most of your career, as you mentioned earlier. How did you decide to get started on the plaintiff side? What led you to that, and maybe what led you to the plaintiff side antitrust work in particular?
Well, as I said, I grew up in San Francisco. I went to Cal. I came from a background where I wanted to help people. Most importantly, I wanted to be in court. I consider myself a trial attorney. They're litigators and trial attorneys, and I think there's a distinction there. And as Scott said, I've written on this and spoken about it. I look at every case as if it's going to be a trial from the very beginning to the very end, and what can I prove? And to me, that's just a fascinating thing. I've always not really liked, throwing barriers in the way of other people in cases. I like to be efficient, and I like to prove the case and, get on with it, not go down dry holes. And I always felt, and I did for 2 years on the defense side, it was more about, trying to keep everything at a slow walk. And on the plaintiff side, you got to move fast. You got to move with alacrity, and you got to, know where your finish line is and not divert. So I think, the trial work has been really what has driven me towards the plaintiff side. You don't get many trials these days anymore, unfortunately. And the bigger cases you get into, the less trials there are. I was very fortunate to try back in 2012 one of the largest antitrust class actions in San Francisco, the LCD case. And that was just an amazing experience. But I didn't start there. I started with very small plaintiffs' trials, PI cases, things that took 1 or 2 days to try, if you can imagine, whereas these cases that we work on and a lot of people do here at ABA in the antitrust section are so massive that, they take sometimes months to trial. So there's a certain element to being the one standing in front of a jury and saying, my client's been wronged, and you have justice in your hands, and we want to see you set it straight. And I like that role a lot better than the other role.
Mm-hmm. Yeah, that makes sense. I know I was a part of the LCD case as well, and that entire experience was just a really interesting experience for me. Do you think you'll have another trial like that in your future?
I hope so. I mean, the gestation period for these cases is a long time. One thing on the plaintiff side, which I'm sure Scott appreciates now, is that there's a lot of risk in these cases. You have to be entrepreneurial in your cases. You have to take cases which hopefully will result in a good result for your clients and for the class. But they can take years. And, one thing that's changed dramatically is the law has made it harder on plaintiffs to prove their cases, both from a pleading standpoint, from an expert standpoint. You can spend millions of dollars prosecuting these cases, and that's a lot of risk. You can't have too many $1 million cases that go south on you in a row before you have a problem.
What is the old Cardozo opinion with the flopper, right? The amusement park ride. The timorous may stay at home. That's what it's like. It's I admire all those who are able to start out as plaintiffs' lawyers, and I suspect they all have pretty good accountants to deal with things like phantom income that we don't think about on the defense side, and the risk that you face. It's absolutely true. Bruce is absolutely right about that.
That actually leads me to another question that I had, which is how do you find your cases without giving away all your secrets to other lawyers who might be in the same position as you? But how do you go about finding those cases that are really worth it to you to take on? And what advice do you have for other people out there who might be thinking about switching to the plaintiff side?
It's definitely one of the most important questions for anybody who wants to go on the plaintiff side, starting out on the plaintiff side. It's not obvious how you get clients and how you market. I mean, I'm lucky now. Scott's lucky, his firm, because they have reputation. We have a reputation, so we have clients come to us, and we have returning clients from other cases, and people want to retain us. So that's great. But if you're right at the beginning, it's not necessarily the case. It's really about networking. Most of the plaintiff side cases come on referrals. So when you're here, like at the ABA, for example, or you go to an ABA conference, we'll talk about one a little bit at the end, it's about meeting people. You never know who might have a client for you. And if you build a relationship and a case comes up, then, that's how it works. We're constantly looking at subject matter for cases, but, it's not obvious to young attorneys how to go about marketing themselves so that they can get clients. Technology is a great thing, but you can't just do it through websites because, the interface with the website, you might get, a cold, call, or somebody will ping you on the website, but it's really about somebody out there saying, I want Bruce or Scott as my attorney. And it's a real intangible type of process.
It's unique for me too on this side of the V, having represented defendants much of the time, in that I do find a number of older corporate clients who come back after 4 or 5, or in one instance even 20 years, and are thinking about where they may actually have anti-competitive conduct that they're facing in the marketplace, and whether there's some way for them to redress it. And that's great. I feel like I've opened some of their eyes to those things. But one thing that Bruce has left out, because he covered so much, is we're both voracious readers, and we will see things in the New York Times, the Wall Street Journal, one of the newspapers out there in San Francisco. I think there are still 2 left, right? The Chronicle, the Oakland Tribune, or whatever it may be. And people think a lot of the time that plaintiffs' attorneys just file what the Department of Justice does, what the FTC does, what the state attorneys general do. No, many times we develop cases on our own, and we see things in the marketplace that we're able to think about, when we put our head down on the pillow, or in the shower in the morning, and the light goes off. And those are really the most rewarding ones.
And that's a very important point, because 2 cases I can point out that I've done, there were no government investigations. Mm-hmm. You hear a lot of the time that we file follow-on lawsuits, and that does happen. That's obvious to anybody who does this. But the Potash case, which I argued all the way to en banc to the Seventh Circuit, was a case we developed completely on our own, because we have had agricultural clients who were saying, the price of this doesn't make any sense. The poultry case, the same thing. Almost 2 years of investigation into that case. No investigation currently. And that, to me, if you develop a case and you bring it to fruition and you win that case, that's really that's something that's really rewarding. And I mean, the DOJ and big firms, they bring plaintiffs' cases too, but they have so much in the way of resources to bring those cases. And when you get a true plaintiffs' class action firm and they bring a case like that, they developed it. I think it builds street creed, number one, and I think it also shows the world that we just don't follow everything that the DOJ does.
I think that's right, and I think one thing that it leads to too, which we haven't discussed, is, and I think Bruce would agree with me, on the plaintiff side, there are terrific opportunities for younger lawyers to develop all of those skills in terms of developing a case for trial, in terms of understanding the entire litigation process, in terms of getting opportunities to do depositions, to argue motions, and so forth. That by necessity, by virtue of our size compared to large defense firms, our resources being our own, and being able to rely upon everybody in our firm to do as much as possible in a case, open a whole world of opportunities for younger lawyers that aren't necessarily there for them, in the MLaw 100.
Yeah, my son, Alex, is a second-year attorney in my firm. He's here at ABA. And the thing that fascinates me about watching him is I don't want him to be just like me, and we've had that conversation. But he has developed these skill sets on his own, in his own way, based on his own generation. And in a lot of ways, I think they're stronger than some of the skill sets I had, at that point in time. Obviously, technology has a lot to do with that. I mean, I'm from the school where I used to pull books out of the bookshelf and look up cases and, make photocopies of them and bring them to court to argue. So, but I think young attorneys, young plaintiffs' attorneys, diverse young plaintiffs' attorneys is very important. And that's why for the last 5 or 6 years, I did a plaintiffs' task force. And then we did the Global Private Litigation Committee, which is not just plaintiffs, but it's focuses on plaintiffs type cases. And we have a very diverse, good group of people, and it's very important to ABA that we continue that initiative. We cannot let down. I mean, this organization is, what do you think, Scott? 80% defense firms?
Oh, it's well over 80%. I would say. I think it's approaching 90. But you know what? In past years, it's probably been 97. So it's getting there. And after all, everybody on the defense side needs us.
But the one thing that's absolutely true, and I've seen this from the plaintiffs' reception that we had last night, every year growing, as Scott mentioned, plaintiffs' attorneys are more fun. It's absolutely clear to me.
I know I had fun on the plaintiff side when I did that as well. Why don't you guys talk to me a little bit about what you see as one of the biggest obstacles facing you on the plaintiff side in the work that you do?
Well, we could write it down. I wonder if we might have the same response. Rule 23. I think class certification is getting so difficult, so complex, frankly, so frowned upon by many members of the Supreme Court right now, so expensive, and so incredibly hard for judges to deal with in terms of the economic regressions and other modeling that occurs in the context of an antitrust class action, that it has become, a real impediment potentially to seeking redress in those cases in the United States in a way that, frankly, it hasn't, and I can say this, in many, many, many years. It used to be routine when I was on the defense side that in a price-fixing case, the class got certified. If it was horizontal competitors, it happened. And I can remember being at a NERA conference, an economic conference 15 years ago, and the question went out around the room, who in here has defeated class certification in a horizontal price-fixing case? When I was on the defense side, I was one of 2 hands out of 70 venerable lawyers that were in that room. Now it would be a lot more.
Yeah, that's absolutely right. I started long enough ago that I actually have filed class cert motions that have been granted where we didn't have an expert declaration.
And that will never happen now.
It could never happen now. I mean, we basically had the attorney declaration with whatever you had uncovered in your investigation and what discovery had uncovered with the documents attached. And the rule effectively was that the conspiracy is the predominant fact that overrides everything else. We now have so many permutations as to what, individual facts may be. Do you have the whole class in? Are you leaving people out? How do you do that? Indirect cases, direct cases. The economists have just, it's a boon for them. It's not a boon for plaintiffs' counsel. The expense of litigation is chilling the justice that plaintiffs can receive in class actions. It's simply as, straightforward as that. And I'm not sure what we can do about it other than try to go back the other way, but we certainly don't have a Supreme Court that's going to let us go back that way right now.
Do you ever think about focusing more on individual plaintiffs instead of class actions as a way to get around that?
I have. And I have done that. We do have individual clients. I know Scott does too. Here's the problem. It's a whole different dynamic. If you have an industry which is just fraught with collusion and the marketplace is being corrupted and there isn't competition, one client, even a big client like Dell or whatever, they can't really change the market themselves, but a class action can. Sure. And it's often forgotten that almost all these class actions have injunctive relief claims as well. And trying to fix the structure of the market can be not just about money, but also making things better going forward in the future. So to me, in the right case, I have no problem representing individual clients. We've even been on the defense side at our firm, even though we're mainly a plaintiff's firm. I just think the class actions is what really gets you where you need to be if you're trying to fix something.
Yeah, I agree with that in most instances. There's certainly some cases where, and we represent individual claimants both in litigation and not in litigation in many, many circumstances. There are some instances in which, to be sure, they can do better than they would in a class action, and you will see, an opt-out case in those circumstances. But there are a lot of situations in which, frankly, as a corporate client, you don't want to stick your neck out. You don't want to have your head over the parapet, particularly if you've got ongoing business relationships with a very important supplier. 2 issues ago in the Antitrust magazine put out by the section, Brian Henry and I and one of my associates did an article, in fact, on just these kinds of decisions that in-house counsel have to face, called a cartel damages recovery, a roadmap for in-house counsel, and it really is a road with a lot of different turns in it. So it happens, but Bruce is right. It's a much more difficult decision-making process for companies.
Thanks for sharing that, guys.
And bear in mind, too, it's right now, in large part, the only recourse that's available for many companies overseas. That's changing in Europe. You are seeing collective redress now. You are seeing in particular jurisdictions, the Netherlands, the United Kingdom, the opportunities, for class actions on an opt-out or opt-in, depending upon where you're located basis. But it's the exception, not the rule.
And there's got to be something to it, because back when I started, U.S. DOJ, they were the lead sled dog. Mm-hmm. They started all these cases, and then the EC got involved. But now there's over 120 competition authorities around the world. So it is definitely a global practice now. And even for a firm like ours that doesn't have offices in Europe like Scott's firm does, we nonetheless have to be cognizant of what's going on in Europe. Perfect example is I'm lead counsel in the German automotive case that's pending in front of Judge Breyer in a district court in San Francisco. And that all resulted from investigations overseas with foreign corporations obviously sell their cars in the United States. So the antitrust jurisdiction is here as well. There's lots of things going on over there with the comp authorities, not only the EC, but the German comp authorities and others that, 20 years ago, that wouldn't even been in my brain. But now I have had to expand my horizons, which is probably a great segue to give a blatant plug.
Right?
Yeah,
you promised us,
Scott last year was it last year or year before?
It was last year.
Last year. God, time flies. He was the chair, and I helped him out as one of the committee members for a conference called Global Private Litigation Conference in Amsterdam, which was a wonderful thing. And it was highly successful for a first-time program with ABA, and we're doing it again in June of next year, 2019, in Berlin. It is a program that, we talked about how you get clients and how you build relationships. I think that's one of the best programs that ABA has for doing that, because it'll be largely plaintiffs' attorneys, claimants' attorneys over there, and the interrelationship that you can develop in this program, I think, is terrific.
But it's an opportunity for defense attorneys, not only to learn, but as Bruce said, to spend some time with the more fun half of the bar. So.
Yeah, we did have a lot of defense attorneys, and by the way, when I talk to my defense friends that are candid with me, they say when they go to things that the plaintiff's perspective is set forth. They like that. They want to hear it. They want to know where the secret sauce is from our perspective, because that helps them in their cases. If you have just a bunch of defense talking heads, sometimes you're just hearing stuff that you already know, and we are more fun.
I think we're starting to wrap up a little bit and getting close to running out of our time, but I wanted to ask you a few questions that I think will be particularly relevant to young lawyers. We've talked a little bit about networking and what young lawyers could do if they're interested in getting on the plaintiff side, but other than networking, what would you recommend to young lawyers who are interested in learning more about working on the plaintiff side?
This is a pet subject for me. I spent 12 years on the UC Hastings board. I was chair of the board for 2 years, and I interacted with law students during that entire period of time. Obviously, I have a son who's a lawyer. And the number one thing that young attorneys kind of are hesitant to do, which I say you have to do, is go find somebody that has experience and talk to them. Find a mentor. Find somebody that you can call up on the phone and say, hey, I was thinking about this. What do you think? There's a little hesitancy, even when there's over 3,000 people at ABA, and you're having coffee together. The young attorneys tend to hesitate a little bit, and I would just encourage them. Every one of us, I know Scott and me for sure, they came up and asked a question, wanted advice, wanted a lead on this, that, or the other thing, bounce ideas off of us. You got to do it. You can't be afraid.
That's really good advice. I know sometimes I worry about taking up time of someone who I know is really busy, but it's good to hear that it's a welcome invitation. So I appreciate that.
No, absolutely not. And I think we are not too busy for that. I think Bruce and I have both done over the years the section's formal mentoring program and taken on an individual. And it's happened organically, too. We've done it informally many, many times, I'm sure. It's a terrific response. The other piece I would add, frankly, and it applies to defense lawyers as well for the younger folks, go out and take on a pro bono case, because not only is it going to be rewarding, but you're going to get a sense of what it's like to be a plaintiff's lawyer, to really go out and develop a case, have that direct relationship with a client, and potentially have to seek a result with, the assistance of a partner or a mentor, but largely on your own.
Right, and by the way, there are programs in all the district courts for pro bono cases, and when judges get pro bono or individual cases where the individual doesn't have an attorney, they love it when an attorney comes in and picks up that case, especially if it goes by summary judgment and there has to be a trial. You can get trials out of that pro bono program, in all the district courts.
That's great. That's really good advice. So aside from the formal mentoring, which I know you mentioned, Scott, and then, of course, the upcoming conference that the ABA is putting on and you all are participating in, are there any other ABA antitrust section opportunities that you would recommend young lawyers to look into, like a particular committee or something like that young lawyers should be looking into opportunities to participate in?
Well, another plug. Here we go, Bruce. The Global Private Litigation Committee is actually the fastest growing committee in the section by far. Grew by 33% in terms of its membership last year. Very active committee members in terms of their output, in articles and in programs, and it's a terrific resource, as well as putting on the conference in Berlin next year. So I would say that, and I think we're seeing more, not from our perspective enough yet, but more programs here at the spring meeting that are plaintiff side oriented. So those are two recommendations I would make.
I couldn't agree more. And then young attorneys should definitely go to the young lawyers events and participate in anything that the young lawyers do. They're everywhere, and there are opportunities everywhere. But yeah, the Global Private Litigation Committee, which started as a task force that Scott's partner, Mike Hausfeld, was involved with, really was the whole purpose of it, was to bring to the forefront a committee that, presented the plaintiff side as much as it could. Again, no committees can be just plaintiff or defense, but, we wanted something that could be the focal point for plaintiffs participating, and it really has grown into that. So I encourage everybody to join that committee.
Well, thank you. It looks like we have just reached the end of our program. I wanted to thank both of our guests for joining us today. Thank you all so much for being here. If our listeners want to reach out to you or perhaps want to ask you more about what it's like to be on the plaintiff side and get some advice from you on their own career, how can they contact you all? Fastest way for me is just to go to our website. We've just redone it, so we are proud of it. Hausfeld.com, Hausfeld.com, and you can. I think my bio is up and done. You can go there to Scott Martin and find my contact information.
Probably the same for me. www.pswlaw.com is our website, and I'm happy to give people my email since it's on the website. It's bsimon@pswlaw.com. Right. Thank you both. I really appreciate it. This concludes another podcast from the ABA section of Antitrust Law Spring Meeting 2018. If you like what you heard, please find us and rate us in Apple Podcasts. I'm Melissa Whitehead, and until next time, thank you for listening.
The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by, Legal Talk Network, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.